Welcome to the 18th lecture of the Common Law Lecture Series. And for guests who have visited the faculty on the new campus for the first time, let me extend our warmest welcome. First established in the year 2005 with the strong support of the judiciary, it is remarkable that this is already the 8th year and the 18th lecture of this series. The lecture tonight is of particular significance. While the Chief Justice has been a staunch supporter of the faculty and has delivered lectures in the faculty before, it is the first common law lecture delivered by the Chief Justice in his capacity as the Chief Justice. These lectures also marks the complete integration of the new home of the faculty with the rest of the university. We are fortunate to have an entire building that's dedicated to the Faculty of Law, and for the first time in the last 40 years of history, this is the first time we have a complete building on the campus for law. But while the faculty has moved to the new campus since last summer, the faculty is somehow separate from the rest of the campus by a partition on the university street at the ground floor due to ongoing construction work. So this has made it somehow difficult for visitors to find the faculty. The partition was lifted today so that linking the university with the rest of the campus, and this marks the through train that marks the completion of the new faculty building. And there's probably no better way than to mark the formal completion of the new home than this lecture. And with this through train in place, the title of the lecture on constitutional interpretation could not be more timely or appropriate. We are privileged that this lecture series has been graced by the most eminent speakers in the common law world. It is of no exception this evening. The Chief Justice needs no introduction. Having been called to the English bar in 1978, he has a distinguished career, first in London and then in Hong Kong. He was called to the Inner Bar in 1993. He joined the bench and became a judge of the Court of First Instance of the High Court in December 2001, and made a record of being elevated to the Court of Appeal within months, and became the Chief Judge of the High Court in July 2003, a position he held until he became the Chief Justice in September 2010. Mr. Justice Ma has extensive experience of public service in Hong Kong. He has served on the Hong Kong Futures Exchange Disciplinary Appeal Tribunal as Chairman of the Building Appeals Tribunal, Deputy Chairman of the Secretaries and Futures Appeals Panel, the Deputy Chairman of the SFC Takes Over Appeals Committee. He was elected an Honorary Bencher of Grace Inn in 2004, making him the third person in Hong Kong conferred with such honor. He is also an Honorary Fellow of Harrison and Chester College, Oxford, and we are privileged to have him as an honorary lecturer of our faculty. For his great contribution to Hong Kong, he was conferred the Golden Bohemia Medal, the highest honor that can be conferred in Hong Kong. For anyone who knows the Chief Justice, one cannot but be impressed by his good sense of humor and his warm personality. So ladies and gentlemen, let's welcome the Honorable Chief Justice.
Professor Chan, thank you very much for that rather marvellous introduction. This is a very marvellous place. I can well understand why one of our former judges, I don't know whether he's here, Anselmo Reyes, why he left the judiciary. I'm somewhat tempted also to leave the judiciary. I wonder whether there's a vacancy for a part-time lecturer. So, ladies and gentlemen, I thank the University of Hong Kong's Faculty of Law for the honour of being invited to deliver today's lecture in the Common Law Lecture Series. It is the most prestigious series of law lectures in Hong Kong, and one that I have much admired through the years. I've chosen as the topic constitutional interpretation, with a special emphasis on our Constitution, the basic law. It is a topic that provides much legal fascination, but is often misunderstood. In the words of Justice Antonin Scalia, the well-known Associate Justice of the US Supreme Court, constitutional interpretation is a pizzazzy topic. Pizzazzy is spelled P-I-Z-Z-A-Z-Z-Y. I tried to calculate how many points you can get on the Scrabble board for that. It's about 1,000 points. For me, it is a topic worth studying closely. The way in which a constitution is interpreted, and we are here, of course, referring to the exercise of interpretation by the courts, reflects the very character and characteristics of a territory's judiciary, and ultimately the true character of a community and its history. In a recent lecture delivered just over 2 weeks ago at the Chinese University, I talked about the essence of our society, looking predominantly at the importance of the constitutional document we know as the Basic Law. The importance of that document cannot be overstated. It is the document that provides the foundation from which Hong Kong maintains its prosperity and stability, and which allows the community to build on it. Its interpretation then becomes critical. The Basic Law was promulgated on the 4th of April 1990 and came into effect upon the resumption of the exercise of sovereignty by the PRC over Hong Kong on the 1st of July 1997. Its origins, contents, and the carefully chosen phraseology reveal a number of themes which I believe give much guidance and insight to the right approach in its interpretation. As the preamble states, the status of Hong Kong as a special administrative region operating under the principle of one country, two systems recognizes the importance of maintaining the prosperity and stability of Hong Kong and the need to take into account Hong Kong's history and realities. A large part of Hong Kong's history and a great contribution to her prosperity and stability was Hong Kong's system of law. This system of law is the common law system, and it is expressly preserved. Article 8 of the Basic Law states that the common law, rules of equity, and customary law shall be maintained, subject, of course, to other provisions in the Basic Law itself and legislative amendment. Article 18 is also in mandatory terms that laws in force in Hong Kong shall be this law, meaning the Basic Law, the laws previously in force in Hong Kong, as provided for Article 8, which I've just read, and the laws enacted by the legislature of the region. A third repetition of this occurs in Article 84, which states that Hong Kong courts shall adjudicate cases in accordance with the laws applicable in the region, as prescribed in Article 18. It is a point of some curiosity that the Basic Law, as a constitutional instrument, does what, I would surmise, many other constitutional instruments do not, namely, repeats itself. This repetition must be deliberate, I would submit, to add emphasis. A treble, if not quadruple repetition, also occurs in relation to judicial independence. And here, see here, Articles 2, 19, and 85. Article 82 refers to the power of final adjudication vested in the Court of Final Appeal. But it is the continued operation of the common law which is key. The theme of continuity runs through the Basic Law. This is an important theme. It is clear from many of its articles, those institutions which have in the past contributed to Hong Kong's prosperity and stability would be continued. The system of law is a prime example of this. This is, of course, not to suggest that continuity of established institutions like the common law system was the only function of Basic Law. There are, of course, new facets which were introduced by the Basic Law, for example, such as the setting up of the Court of Final Appeal itself as the final appellate court for Hong Kong, the identification of classes of persons entitled to be permanent residents of the region. This is Article 24. Another theme which is apparent from the content of the Basic Law is its reference to international aspects. Nowhere is this more apparent than Article 39. 39.1, the first paragraph of Article 39, states provisions of the International Covenant on Civil and Political Rights, the ICCPR, the International Covenant on Economic, Social and Cultural Rights, and International Labour Convention as applied to Hong Kong shall remain in force and shall be implemented through the laws of the Hong Kong Special Administrative Region. The PRC is a signatory to the ICCPR. The ICCPR was implemented in Hong Kong by the Hong Kong Bill of Rights Ordinance. It provides what has been described as the minimum standards for rights which are internationally recognized. This was in the CFA decision of Gurung Bahadur. In the interpretation of rights based on the ICCPR, it is appropriate, indeed I would say desirable, to take into account international jurisprudence and case law. And this is the well-known case of Sheng Huok She. It's also to be noted that under Article 84 of the Basic Law, it states that the courts may refer to precedents of other common law jurisdictions. Like many constitutions, many of the provisions of the Basic Law are couched in general terms, leaving it for others to interpret their meaning or to determine how rights will operate in any given set of circumstances. Take, for example, the right to access to the courts contained in Article 35. This is a right stated in very general terms. However, in the practical operation of the right, it does not entail unrestricted free access to the courts. Thus, a system whereby leave to appeal is required will not fall foul of the right to access to the courts. In the case of the Court of Final Appeal, while Article 82 of the Basic Law provides that the power of final adjudication is vested in the CFA, access to the court can be regulated. In other words, there may be restrictions or limitations on access to that court, provided that the proportionality test is satisfied. You all know what the proportionality test is. It's in three parts. The restriction or limitation must pursue a legitimate aim. The restriction or limitation must also be rationally connected to the legitimate aim, and the restriction or limitation must also be no more than necessary to accomplish that legitimate aim. The requirement of leave, which is in the Hong Kong Court of Final Appeal Ordinance, is one such restriction or limitation. These themes and facets of the Basic Law, history, the continuation of the common law system, the general concept of continuity, the international dimension, are all important when one approaches the question of the interpretation of the Basic Law. The need to interpret the Basic Law will frequently arise given the fact that, like most constitutions, it is a living instrument. If you'll forgive the expression, a constitution is often a blueprint for the community to which it attaches, and it is intended to apply not just in respect of a static point in time, but to the present, the future, and to every contingency or event, whether foreseen or unforeseen, to be faced by that community. Not all provisions in a constitution will have to evolve or adapt to changing times. For example, it is difficult to see how the inviolability of the freedom of the person, that no person shall be subjected to arbitrary or unlawful arrest, detention, or imprisonment, can change with the times, or say the requirement that the executive authorities and legislature will consist of Hong Kong permanent residents. But many provisions will. As long as goes 1908, in the High Court of Australia, Justice Sir Richard O'Connor said in a case called the Jumbunna Coal Mine against the Victorian Coal Miners Association, when referring to the Australian Constitution, said this: "It must always be remembered that we are interpreting a constitution broad and general in its terms, intended to apply to the varying conditions which the development of our community must involve." I've used the term living instrument to apply to a constitution. It is not an original term and is used by many constitutional scholars and judges. In Boyce and the Queen, Lord Hoffman, in considering the Constitution of Barbados in the context of a legislative provision which provided for a mandatory death sentence being imposed for murder, said this: "The text of the Constitution is a living instrument when the terms in which it is expressed in their constitutional context invite and require periodic re-examination of its application to contemporary life." The authorities most often cited among US scholars to make this point are Griswold in the state of Connecticut, where the US Supreme Court, in a 7-2 decision, fashioned a right to marital privacy in order to strike down legislation which prevented the use of contraceptives, and Roe and Wade, well-known case of Roe and Wade, where the court, again in a 7-2 decision, carved out of the 14th Amendment the right to choose to have an abortion. In Griswold, this updating of the US Constitution to meet changing times was engineered through the right in question, the right of privacy, being found in the specific constitutional guarantees having, and I quote here, what were called penumbras formed by emanations from those guarantees that help give them life and substance. This is from the judgment of Justice William Douglas. These sentiments regarding what US scholars call the living constitutionalism theory find an equivalent voice in our courts, in Carling, and also among our scholars and jurists. In the preface to their work, Law of the Hong Kong Constitution, the Dean, Professor Chan, and Professor Lim refer to the basic law as a living reality. It is part of the essence of the common law that it evolves, as surely all law must, to meet the changing needs of the society in which it functions, and that it is the duty of judges to develop the common law to respond to changing needs. Over the past 20 years, in particular since the resumption of the exercise of sovereignty on the 1st of July 1997, it is in the area of human rights in which there have been significant and material developments in Hong Kong. Most people in Hong Kong are aware of this subject and its importance. This is no bad thing at all, and I have often spoken of the desirability of more people in the community being made aware of issues involving the rule of law, human rights, and other important facets of our legal system. All this draws attention to the activities of the courts, and it is in the area of public law, in particular when constitutional issues are involved, where the focus becomes the most intense. There are principally two reasons for this. First, by their nature, public law cases tend to be high-profile cases in which strong views are held by the public as a whole. One is able to identify many such areas over the years. Soon after 1st of July came the series of cases known as the right of abode cases, which today stir much debate. The cases involving torture claimants and asylum seekers, the recent cases on foreign domestic helpers, and those cases which have discussed the power of interpretation vested in the Standing Committee of the National People's Congress. Secondly, in order fully to understand the impact of decisions made by the courts in cases involving constitutional law, one must see the powers of the Hong Kong courts in this regard, and then contrast them with the position in other common law jurisdictions. In Hong Kong, the courts have the power to make declarations of unconstitutionality, whereby legislation can be struck down and rendered invalid. Article 11.2 of the Basic Law states quite simply that no law enacted by the legislature of the HKSAR shall contravene the Basic Law. Section 6.1 of the Hong Kong Bill of Rights Ordinance makes provision for what happens when the Bill of Rights or any provision within it is contravened. The power, indeed it is a duty and obligation to hold that legislative acts may be rendered invalid when not in conformity with the Basic Law, was stated at the outset of the Court of Final Appeals' existence. In Ng Ling, Chief Justice Lee said this: "In exercising their judicial power conferred by the Basic Law, the courts of the region have a duty to enforce and interpret that law. They undoubtedly have the jurisdiction to examine whether legislation enacted by the legislature of the region or acts of the executive authorities of the region are consistent with the Basic Law, and if found to be inconsistent, to hold them to be invalid. The exercise of this jurisdiction is a matter of obligation, not of discretion, so that if inconsistency is established, the courts are bound to hold that the law executive act is invalid, at least to the extent of the inconsistency." This power to make declarations of unconstitutionality and therefore to strike down legislation is not a provision that exists in many other common law jurisdictions. Contrast the position in Hong Kong with that in the United Kingdom, Australia, and New Zealand, where no power exists to strike down legislation. Indeed, in New Zealand, Section 4 of the New Zealand Bill of Rights Act 1990 actually states that no court shall, in relation to any enactment, hold any provision of the enactment to be impliedly repealed or revoked, or to be in any way invalid or ineffective, despite the fact that it may contravene the Bill of Rights. In the United Kingdom, while the court may declare that a piece of legislation breaches the European Convention on Human Rights, it will ultimately be left to the UK Parliament to comply with the court's view. The constitutional arrangements in place in those jurisdictions place emphasis on the supremacy of the legislature. This is not to say by any means that in passing laws, the legislature in those jurisdictions can ignore constitutional requirements. And this is where the role of the courts in the interpretation of constitutional rights becomes key. It is not without significance that in the United Kingdom and New Zealand, for example, a form of statutory direction is given to the courts in interpreting legislation where human rights are involved. There's the well-known Section 3.1 of the Human Rights Act 1998 of the United Kingdom, which provides simply, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with convention rights. In New Zealand, Section 6 of the New Zealand Bill of Rights Act 1990 provides wherever an enactment can be given a meaning that is consistent with the rights and freedoms contained in the Bill of Rights, that meaning shall be preferred to any other meaning. These provisions give rise to interesting dimensions to the interpretation exercise where constitutional rights are involved. I shall in due course focus on the position in Hong Kong, but for the time being just concentrating on the United Kingdom and New Zealand positions, I can see much scope for debate. Both the provisions I have just read appear to allow for quite radically different interpretations to take place. One where the relevant enactment under scrutiny can be interpreted without any substantial regard to the applicable codified rights, whether they're contained in the Bill of Rights or in a convention, provided this is a reasonable interpretation. Contrast another interpretation where such rights assume an overall importance so that this consideration would alter what might otherwise be a natural reading of the provision in question. This is much more than a philosophical or academic question. As Chief Justice Spiegelman, somebody will have noticed that this afternoon it was announced that the Chief Executive accepted Geoffrey's recommendation that Chief Justice Spiegelman is to be a non-permanent judge of our Court of Final Appeal. Now, as he's remarked, the critical issue that arises in the application of rights-compliant interpretation provisions is how far a court can go in modifying the application of the statute and still be undertaking a task that can be correctly identified as one of interpretation. He draws attention to different approaches of the laws in a well-known case of R against A. At paragraph 44 of R&A, Lord Steyn stated that the interpretive obligation contained in Section 3 of the Human Rights Act 1998 was a strong one, and which applied even in the absence of any ambiguity in the language of the relevant provision. This echoed Lord Nichols in Guidan. As Lord Steyn stated as well, under ordinary methods of interpretation, a court may depart from the language of the statute to avoid absurd circumstances. Section 3 goes much further. Undoubtedly, a court must always look for a contextual and purposive construction. Section 3 is more radical in its effect. To be contrasted with this radical approach was the view of Lord Hope of Craighead, who said this: the rule of construction which Section 3 lays down is quite unlike any previous rule of statutory interpretation. There is no need to identify any ambiguity or absurdity. Compatibility with convention rights is the sole guiding principle. That is the paramount object which the rule seeks to achieve. But the rule is only a rule of interpretation. It does not entitle the judges to act as legislators. In Sheldrake against DPP, Lord Bingham, with whose reasoning Lord Steyn and Lord Phillips agreed, said that the interpretive obligation under Section 3 was a very strong and far-reaching one, and may require the court to depart from the legislative intent of Parliament. He also said this, referring to Guidan, in explaining why a convention-compliant interpretation may not be possible, members of the committee used differing expressions. Such an interpretation would be incompatible with the underlying thrust of the legislation, or would not go with the grain of it, or would call for legislative deliberation, or would change the substance of the provision completely, or would remove its pith and substance, or would violate a cardinal principle of the legislation. All these expressions, as I respectfully think, yield valuable insights, but none of them should be allowed to supplant the simple test enacted in the Act, so far as it is possible to do so. The New Zealand courts appear to have taken a more cautious approach to the English courts, and here, for those who are from New Zealand, the well-known cases of Moonen and the Film and Literature Board of Review, where there's a powerful dissenting judgment from Chief Justice Elias. As events to some extent have shown, this ability, indeed it is more than that, is prescribed by statute. The ability vested in the courts in the United Kingdom to interpret legislation to ensure that it is human rights compliant can lead to tensions between the courts and the legislature. The legislature may well intend to pass tough legislation designed to inhibit the scope of human rights. Take the case of legislation regarding terrorists and terrorism. But the courts are duty-bound to give human rights a broad measure of applicability, and as is now tripe law, human rights are to be construed in a generous way. Tensions between how the courts construe legislation when viewed through a human rights prism and the policies of governments of the day lead to debates over the constitutional role of the courts, and in particular to the warning given by Lord Hogarth Craighead that courts do not act as legislators. In an exceptional situation, a government may possibly even choose to ignore what the courts have held to be the constitutional position, but such a course of action would be bound to provoke considerable controversy. I mean, in the United Kingdom, in a case called the Queen against Secretary for State for the Home Department ex parte Sims, Lord Hoffman said that the constraints on the British Parliament were ultimately political, not legal. In Hong Kong, where the courts do have the power to strike down legislation which does not comply with the basic law, it is not possible to refuse to comply with the court's ruling unless the law is changed. In this respect, while it is generally possible for the legislature to amend the law to overturn the effect of a court ruling, this is less straightforward in the case of constitutional rulings. Where a declaration of unconstitutionality is made, legislative amendment will be possible only if such amendment is itself also constitutional. This discussion underlines both the relevance and the importance of constitutional interpretation by the courts. The Hong Kong courts approach the exercise of constitutional interpretation by the application of common law principles, as it is bound to under the basic law. There are no guides to interpretation contained in the basic law itself, either as to how the basic law is to be construed, or as to how the basic law should be applied, for example, to legislation. We do not have the equivalents of Section 3.1 of the Human Rights Act 1998 in the United Kingdom, nor Section 6 of the New Zealand Bill of Rights Act. The duty to construe the basic law in accordance with common law principles is a constitutional duty on the Hong Kong courts. There is no other guidance or leeway given to the courts in this regard. True it is that under Article 158 of the Basic Law, the Hong Kong courts will be bound by interpretation of the basic law made by the Standing Committee of the National People's Congress. But that provision does not guide the courts here as to the proper approach on the interpretation exercise, only on the consequences of an interpretation made under Article 158. The Court of Final Appeal has on a number of occasions discussed that article, most recently in the Vallejos case, the foreign domestic help disputes. In construing the basic law itself, the court's initial point of examination is to look at the words themselves. Generally, the common law method of interpretation, whether of a contract, a statute, or the basic law, is to assume that the intention behind a provision is to be found primarily in the words actually used. If the words themselves are clear and unambiguous, there may be little room or need to go further. Quite simply, the words mean what they say. Such an approach, simple and yet surely correct as a starting point, is to be contrasted with other somewhat complicated theories of constitutional interpretation that, as far as they go, are unobjectionable as long as they are regarded more as tools that guide rather than as strict doctrines of interpretation which allow for no exception or flexibility. In the United States, there is a perennial debate as to whether originalism should be the approach to construing the U.S. Constitution or some other approach. In a nutshell, originalism entails interpreting a constitution according to the original intentions or understandings of the Constitution's framers or ratifiers. So far as the U.S. Constitution is concerned, the most attractive aspect of this has been said to be the link to, quote, the revered founding fathers. Justice Scalia of the U.S. Supreme Court, whom I mentioned earlier, is a well-known and eloquent advocate of the school. The fault I find with this theory is that it gives rise to too many complications in its application. To begin with, are such intentions or understandings of the framers to be understood as being subjective or objective, or, as sometimes occurs in the law, both? There's an amusing opening to an article. The article is called Original Intent or Evolving Constitution by Professor Barbara Perry, the Carter Glass Professor of Government at Sweetbriar College at Virginia. And she begins in this way. In the mid-1980s, an otherwise academic debate over constitutional interpretation broke into the popular press. The controversy surrounding whether federal judges should read the United States Constitution according to the original intent of those who established it, or by evolving contemporary principles, even prompted political cartoonists to enter the fray. In one cartoon, the then Attorney General, Edward Meese, proclaimed the Constitution was meant to be interpreted only as the Founding Fathers intended. The artist then flashed back to the dawn of the new nation, with Benjamin Franklin commenting to his fellow founders, well, of course, you can't prevent some yo-yo 200 years from now from misinterpreting us. I doubt the originalist approach to be the starting point in the common law method of interpretation. It seems to me to put too much of a premium on the intentions, subjective or objective, of the framers, rather than on the words themselves. There's, of course, the problem of trying to discover just what those intentions were. All sorts of evidential problems may arise as well. This would probably explain why, in our courts, the use of extrinsic material in the construction of constitutional and other provisions is seen as a final resort rather than as a first. Most cases do not reach the stage. Sometimes the starting point of the interpretation exercise, that is, looking at the actual words used, will also be the end point. Take, for example, the treatment by the CFA of the term born, contained in Articles 24.2.1 and 3 of the Basic Law. We all know what those are. It's difficult to see how that word can really mean more than the event of birth. In Vallejos, the foreign domestic helper case, the CFA contrasted these provisions with a more open-texted provision relating to ordinary residence contained in Article 24.2.4 of the Basic Law. The judgment, paragraph 79, the court said this: the open-textured and flexible nature of that expression may be contrasted, for instance, with the word born used in two of the other articles of entitlement to permanent resident status in Article 24. Chinese citizens born in Hong Kong and persons of Chinese nationality born outside Hong Kong, of those residents listed in categories 1 and 2. The central triggering requirement in each of those categories is the event of birth, a concept which is much more closed and which admits of much less flexibility than the requirement of a continuous 7-year period of ordinary residence under Article 24.2.4. This was indeed the conclusion of the court reached in Director of Immigration and Chong Kung-yun. Concentrating on the actual text of a provision in the Constitution is, however, not to succumb to that doctrine known as textualism. Textualism focuses on the literal meaning of provisions so much so that nothing else is really looked at. This school of thought also suffers from the same limitation as originalism, namely its inflexibility. I can of course understand the unwillingness of judges to go beyond their constitutional remit and be accused of acting as legislators, but in construing constitutional provisions by having recourse beyond just literal words used, judges are attempting to do precisely what their constitutional duty requires, to interpret the law by discovering what the intention is behind those constitutional provisions. A principled approach is naturally called for. After all, no one has suggested that constitutional interpretation is some form of judicial free-for-all. But the approach needs to be a flexible one. Flexibility is required because different provisions in a constitution may require different approaches. I made a point at the outset saying that constitutional interpretation is often misunderstood. Such misunderstanding arises from the adoption of inflexible approaches. In Chongfeng Yun, the Court of Final Appeal reiterated the approach of the courts in construing provisions of the Basic Law, in construing provisions of the Basic Law, there had to be a regard not just to the language of the article in question, but to its purpose and context. The court said this: their task is not to ascertain the intent of the lawmaker on its own. Their duty is to ascertain what was meant by the language used and to give effect to the legislative intent as expressed in the language. The courts do not look at the language of the article in question in isolation. Language is considered in the light of its context and purpose. The exercise of interpretation requires the courts to identify the meaning borne by the language when considered in the light of its context and purpose. This is an objective exercise. While the courts must avoid a literal, technical, narrow or rigid approach, they cannot give the language a meaning which language cannot bear. This emphasis on context and purpose will very often provide the answer in any given case. Sometimes the purpose may be evident from the provision itself. Even where expressions have commonly been used in other legal provisions, it is still critical to ascertain first the context and purpose of the provision in question. In the Vallejos case, to which a number of references have already been made, it's a very good example of this point. There, the courts were faced with the true construction of the words ordinarily resided, contained in Article 24 of the Basic Law. Although this phrase was one which was found in a number of other statutory provisions, both in Hong Kong and elsewhere, the CFA emphasized the need in construing Article 24.24 to look first at the purpose and context of that article. From that starting point, the court was then able to conclude that the concept of ordinary residence for the purpose of that article was a relatively open textured one, and one that required in every case to look at the nature and quality of a person's residence in Hong Kong. For this purpose, as the very wording of the article suggested, as well as another article, which was Article 1542, it was necessary to look at the terms under which a person had been permitted to enter Hong Kong in the first place. The Vallejos case provides a good example of the court utilizing, in a principled way, those facets inherent in the common law method of constitutional interpretation. A literal approach would not have sufficed. I've earlier discussed the question of the interpretation of legislation by reference to human rights considerations and to the absence in Hong Kong of interpretive aids such as Section 3.1 of the UK Human Rights Act or Section 6 of the New Zealand Act. There is no doubt that in Hong Kong it is implicit in the construction of statutes that they should be human rights compliant, although obviously not to breaking point, meaning that the courts will not give a construction to a provision which it cannot reasonably bear. In a case called Coco and the Queen, the High Court of Australia simply said the court should not impute to the legislature an intention to interfere with fundamental rights. That human rights are to be generously construed in Hong Kong is an incident of the common law system and is part of its legacy. The common law has always generously interpreted the width of human rights, even if the courts have not always used this language in its decision. In a footnote, which you'll see if you look at the printed version of this speech, I make reference to a very well-known case decided in the 1940s called Constantine in the Imperial Hotels. This is, you'll forgive my own sort of idiosyncrasy, this is about a cricketer called Leary Constantine. Now, I can see from the majority of people here, you don't know who Leary Constantine was. Leary Constantine is a famous cricketer, later Sir Leary Constantine, even later Lord Constantine. While he was touring with the West Indies, he was not allowed board and lodging at the Imperial Hotel in London because he was coloured. The court held in his favour and is one of the strongest cases against racism, even though there's no mention of human rights. That case is also notable for two reasons. Representing Leary Constantine was Sir Patrick Hastings and Rose Heilbronn. Rose Heilbronn was later to become England's first Queen's Counsel and first woman judge. The law reports in Hong Kong, in the United Kingdom, and in many other common law jurisdictions are replete with references to rights being construed in a generous way. Just as a generous interpretation should be given to fundamental rights so as to give individuals the full measure of such rights, any restrictions on them must in turn be narrowly interpreted. I've now only cursorily touched upon the topic of constitutional interpretation, providing some what really are personal views on it and its importance. The practical application of interpretations of constitutional provisions is, however, of course, the second part of the court's exercise in constitutional cases. This is where there are likely to be real difficulties for the courts. That, nevertheless, is for another day. I'm glad to see I've reached the last paragraph, actually. But I end by paying tribute to the many scholars and jurists who provide a rich source of material for the courts in their attempt, whether in the area of constitutional law or other areas, to arrive at a just, fair, and principled decision. I can do no better than to refer to the postscript. This is a passage, one of my favorite passages in the cases. It's the postscript in the speech of Lord Gough of Cheveley in the well-known case of Spiliada Maritime Corporation and Cancellex, dealing with foreign non-conveniens. He said this: "I feel that I cannot conclude without paying tribute to the writings of jurists which have assisted me in the preparation of this opinion. They will observe that I have not agreed with them on all points, but even when I have disagreed with them, I have found their work to be of assistance. For jurists are like pilgrims with us on the endless road to unattainable perfection, and we have it on the excellent authority of Geoffrey Chaucer that conversations among pilgrims can be most rewarding." Thank you.
Ladies and gentlemen, I think the Chief Justice already indicated that he's going to give a part 2 of this lecture. And thank you, Justice Ma, for this very wonderful lecture. And you have taken us through some of the most difficult issues on the relationship between the court and the legislature, the back issues surrounding the interpretation of Article 158, your preference for a flexible approach where purpose and context dictate most of the outcomes of the cases, and opposed as opposed to the approach focusing on original intent. And also highlight the balance between human rights, compliance on the one hand, and the constitutional role of the court on the other. So with a lecture that covers such a wide-ranging issues, Mr. Justice Ma has kindly agreed to take a few questions from the floor. So if you wish to ask any questions, please first identify yourselves, and please keep your questions short and succinct. Yes, sir. Mike.
Chief Justice Mark, I'm Roger So, a PCLL student. Thank you first for a very informative lecture on constitutional interpretation. Now my question is concerned about the future CFA interpretation, if ever, that may need to revisit a previous CFA interpretation. Now, for example, in the Zhang Hongyin case, the interpretation related to the right of abode of some kind of Chinese nationality people born in Hong Kong have caused some later controversy. If ever, if inevitably, the CFA has to revisit that provision of the basic law, and what measure do you think would minimize the impact on the judicial independence perception of the public? Because, first of all, in the case of a solicitor against the Hong Kong Law Society, the CFA is not bound by any previous decision of its own court, but with the general precedent, it normally would respect previous decision. But if inevitably this is the case that we revisit, what guidance or measure do you think would possibly minimize the impact to the judicial independence perception? Thank you.
Well, of course, you're right to point out the case of solicitor against the law side in Hong Kong is indicating that the Court of Final Appeal is not bound by its previous decisions, but it will not disturb the effect of a previous decision unless, quite simply, it is wrong. How it determines whether a case is wrong will be adopting a principled approach to it. It's got to be shown that it is the usual things. Perhaps the previous court was not referred to an authority or otherwise. But in dealing with any case, whether disturbing a previous decision or not, what ensures the public perception of judicial independence is for the court to act always in a principled way and to have the principled approach which it adopts revealed in its reasoning. I've mentioned this in a number of speeches before, including the opening of the legal year, where I've stressed the importance of reasoning existing in a judgment to indicate to the world in general, not just to the parties of the litigation, the reasoning of the court, the approach of the court, which is based on principle. As long as that occurs, that should give everybody the confidence that the court has acted independently. Where inadequate reasoning exists, that's where people are entitled to be suspicious as to whether other factors have come into play in the court's decision.
Chief Justice, Zhu Tong, a barrister. A very interesting person.
Barrister, did you say, or
a very interesting and personal view of the matter. Can I just ask one question, hopefully get a personal view from you, and look at the matter of the basic law from a slightly different angle? You have mentioned a number of cases in which you were involved, either as a judge, not necessarily in the CFA, but also in the lower courts and also as counsel. Just want to ask you whether you feel, from your experience, both as counsel and as judge, whether there's any aspect of the basic law that you feel may need an amendment.
Well, I don't know whether this actually goes beyond the topic, which is constitutional interpretation. It's obviously when you come across cases where there are problems which arise in the interpretation of the basic law, and very often you're faced with interpretations, quite differing interpretations, which actually on its face look reasonable. I mean, obviously when somebody comes up with a terrible version of what the basic law means, it's easy then to say, well, that's easy one can easily reject that. But very often that's not life in the courts. The courts have to deal with differing, I think, versions of the meaning of a provision, all of which seems reasonable at times like that, when you have difficulties deciding, you just wish that perhaps the basic law could be clearer one way or the other. But that's not to sort of say that that's not really the right approach, because you simply have to interpret it. So if you ask me over the years which provisions I think ought to be clarified, I can see, I'll probably answer it in this way, from a personal point of view, which is what you've asked for. All those provisions have caused me difficulty. I think that's hopefully is a good answer. I think Professor Williamson had a question.
Hi, I'm a PhD student from HKU. Thanks for the lecture. A former colleague of yours on the Court of Final Appeal, I believe, ex-Permanent Justice Bakari, warned of an unprecedented storm ominously brewing over the rule of law in Hong Kong. And I think he's since clarified those remarks, or elaborated them somewhat, to say that he thinks the greatest danger facing the rule of law in Hong Kong is the potential power to interpret the basic law which is potentially vested in the National People's Congress Standing Committee. I was just wondering, in your own opinion, to what extent do you agree with your former colleague?
Sure, how that deals with constitutional interpretation either. Since this is not a court, I shall not be rude and try to answer your question. I think what Justice Bakari meant, you're right, he clarified by saying that what he meant was interpretation by the NPC. Now, one's got to remember first that 158 is there and has to be applied. You can't shirk away from it and say, well, let's pretend it doesn't exist and not apply it. You've simply got to apply it. What he may mean, I don't know, because I've not spoken to him and he's not really elaborated to the whole world about this, is perhaps an overuse of 158. There's an interesting article written by Sir Anthony Mason about this in the, I think it's the Sydney Law Review. It's a very illuminating article in which he discusses Article 158, discusses the constitutional importance of it, the rationale for it, which in fact is perfectly acceptable. The rationale simply being, well, if you have any difficulties over the meaning of the basic law, then you should ask the body which has created the basic law, which is the National People's Congress. This is, of course, the Standing Committee has the power of interpretation. But what he does say is that, well, as with many things, one has to see how it operates in practice. Because, and I've said this before, if every time, let's say, somebody or the government loses, then in the Court of Final Appeal, it then goes off for an interpretation of under 158, then there comes a point when some people may say, well, that's just not on. And much depends on the actual interpretation which comes out of a 158 interpretation. Now, that I suspect is what he means. If that's what he means, then I don't disagree with it. If he means something else, then I don't know. I'll reserve my rights or something. I don't know how lawyers talk these days. Do they say without prejudice? Hope that answers your question.
Thank you.
I'm Sarah Worthington. Thank you for a terrific lecture. I very much enjoyed it. It seems to me, though, that the judges aren't told how to interpret the Constitution. They decide for themselves which methodology they'll adopt. And I sometimes get the feeling that they decide what outcome they would prefer and then work out ways of working towards it. And you might think that Mr. Justice Scalia in the US, where he's adopting originalism, is really thinking that that will be an easy method to get him to the answer that he would prefer. So I like your approach, but how could we be sure that that's the approach that the judges will adopt in the future?
Well, I think the only point I made was that there are a number of approaches which are possible and which fall under the rubric of a principled approach. Now, which approach is a suitable one depends on the circumstances. Now, that doesn't really answer your question, because in a case where the words are clear, I think the court would be intellectually dishonest not to apply the words when they are clear. If they are not clear, then one has to go a little beyond that, perhaps look at other provisions in the basic law. One may even have to look at the history. One may have to look at, as I mentioned in the talk, context and purpose. Now, there is no guarantee as to which is the appropriate method until one looks at it and try to look at it in a principled way. Now, I don't necessarily accept well, what's the best way of putting it? An accusation, let's put it this way, the most unkind way of putting it, that judges decide on the outcome and then work backwards. Now, it used to be said, quite a lot of judges said that they looked at what was the desirable result and then worked backwards from that in order to make the judgment look like a principled one. I never subscribe to that, because I've gone the other way around. And then when the application of principles, and there are always many principles, very often pulling in different directions, and that arrives at a result which just instinctively feels wrong, then one goes back to the drawing board and tries to get it right. Eventually, you may be completely stuck, and you've just got to make a decision. Now, in the old days, you could say, well, the parties can really just go on appeal. Once you get to the court of final appeal, then there is no but to pass it to, and one simply then you have to do the best you can. But always, I would venture to submit on adopting a principled approach. This is the important thing, to adopt a principled approach as opposed to a free-for-all approach, or judges deciding what they think is the real justice of the matter, so they arrive at a result and then work backwards. I know that really doesn't answer your question. Best I can do.
Right, in the interest of time, I'll take the last two questions. One question over there, maybe. The gentleman over there.
Alvin Chung, young barrister. Chief Justice, thank you very much for a very enlightening talk. I believe a previous questioner has already identified the elephant in the room, which is to say the invocation of Article 158 of the Basic Law. Now, as Chief Justice, you've already pointed out, that provision is there is not to be shirked from, and in the event that there is an interpretation by the Standing Committee, the Hong Kong courts are bound to apply it. My question is this: what happens in the event that there is such an interpretation, and yet the duty to comply with that interpretation conflicts with a corresponding duty to read existing legislation or existing provisions of basic law in line with constitutional rights and freedoms? Is this a case of an unstoppable force and an immovable object?
I don't know who the elephant is. Are you referring to me? First question. But the second question is that 158 is actually, I think, very clear in what is intended. And where an interpretation is made by the Standing Committee of the National People's Congress on a provision of the Basic Law, that interpretation will bind the Hong Kong courts. Now, it follows from this that insofar as that meaning conflicts with the meaning which the court would otherwise give to it, well, 158 states clearly, and the cases which have dealt with 158, like the Kong case, Lau Gong Yong case, state quite clearly that the courts are bound by it. Now, I don't know whether you are then asking a higher question, a sort of philosophical question, that what if the court thinks that the interpretation made by the Standing Committee is, let's say, so absurd or so unfair, would the court then follow it? Well, that's a purely hypothetical question. That may be your real question, but but I'll answer the question the way that you've asked it, which is the 158 states quite clearly what the role of the courts is when an interpretation occurs. It's got to follow it.
Chief Justice Ma, I'm a JD student in this university, and I would like to ask a question about constitutional interpretation, and that is, given the Standing Committee has already interpreted several articles of the Basic Law, do you think they have provided sufficient reasoning in their decision to help the court in Hong Kong, including the CFA, to reach a principled judgment when the judgment is needed? Because, for example, the Standing Committee had issued interpretation about political structure in Hong Kong, and that was, I think, in my opinion, it's not yet ruled by the court in Hong Kong at the moment. So in the future, for example, where there are judicial review, do you think the reasoning or the decision from the Standing Committee would be helpful for you to reach a principled judgment? Thank you.
This is a very useful question following on from the last, which is that I think what you're asking is this, that when an oh, sorry, that's it. Oh. I'll carry on since I've started the answer, which is this, that can the reasoning given by the Standing Committee somehow be adopted by the courts, or should it influence the court in some way when the court comes to look at the same matter or at a future matter? Now, one's got to bear in mind that the Standing Committee is not a court. When it comes up with an interpretation, it sometimes has some form of explanation, but doesn't have to. How it arrives at an interpretation is, well, I don't know how, but it is not the common law method of interpretation, not necessarily, or not at all. When it comes to adopting the reasoning or the supposed reasoning behind an interpretation, I think the court here is under real difficulties. And I think nothing in Article 158 mandates that one looks at the reasoning, one looks at what has actually been done. And what has actually been done and what binds the Hong Kong courts is that the meaning of an article in the Basic Law, which is before the Standing Committee, means this, and that meaning binds the Hong Kong courts. One doesn't then go further to try to work out what the reasoning is. And this is my own view on that matter. Otherwise, the court here comes under two real difficulties. The first difficulty is almost an evidential one, which is an ascertaining what that meaning is or what the reasoning is. But secondly, the courts here are mandated to apply the common law and no other system. So it's difficult then from those two starting points to look at the reasoning, work out the reasoning, and then be bound by it or to be influenced by it. That's my view on it. And 158 doesn't say otherwise. 158 is clear. It says when an interpretation is made, well, the courts are to be bound by it. And the Lau Kong Yung case confirmed that.
I think in the interest of time, we would have to call this lecture to an end. I'm sure the audience share with me that you get a good feel of the sense of humor and the warm personality of Mr. Justice Ma. And indeed, if you look back, you will be surprised that it's only just a few decades ago when Lord Denning wrote his first book trying to explain why he decides cases in a particular way. He received warning for disciplinary actions for engaging in judicious conduct. And times has, of course, moved on, and we welcome this tradition that judges are able to share with us their wisdom and experience. And it is particularly valued that Mr. Justice Ma are able to share with us very frankly his own personal view on the development of a very controversial area of constitutional law. And in the best traditions of this lecture, you have given a lot of for us to think about and to reflect on. And needless to say, whatever Mr. Justice Ma said tonight could not be quoted in court. But in the best interest, on behalf of the faculty, I'd like to present a small token. I think the response of the audience speaks by itself. So thanks everyone for joining us. And we have a reception outside, and everyone is invited to join us at the reception. So thank you again, and I look forward to seeing you in our next common law lecture. Thank you.